Senator Rocky Adams. Senator Alvarado.
Here.
Senator Yates. Representative Bridges.
Here.
Representative Frazier. Gordon.
Present in the room.
Representative Marzian.
Present in my district.
Thank you. Co-Chair West.
Present.
And Co-Chair Hill.
Present in the room.
Thank you.
And we do have a quorum, correct?
Yes, we do.
With the quorum being present, the subcommittee is duly constituted to do business today. The first matter of business on our agenda is the approval of the minutes of the last meeting. Are there any additions or corrections to the minutes of the previous meeting?
Motion to approve.
There is a motion for approval. Is there a second?
Second.
We have a motion and a second. Without objection, it is so ordered. Just a quick reminder to everyone that may be joining us by video conference, or maybe you're just joining us on your phone or whatever. Please keep your microphone muted until you would like to speak, and get the message to one of the staff here, and we will recognize you and give you ample time to speak. Before we get started today, in our regular agenda, we have had an addition to our agenda today. The subcommittee has called up an effective regulation for review today, and that regulation is 101 KAR 2095, and I'm going to ask at this time if you will please call that effective regulation.
Personnel Cabinet 101 KAR 2095.
This regulation establishes requirements for classified service, including requirements for the Kentucky Employees Charitable Campaign, employee records and reports, other conditions of employment, and issuance of pay.
Thank you very much. Would whomever is joining us today from the Cabinet please identify yourselves today for the record?
Hello, I'm Rosemary Holbrook. I am the Assistant General Counsel for the Personnel Cabinet.
Hello, my name is Alan Hurst. I'm the Acting Executive Director of the Office of Employee Relations.
Do we have anyone else?
I'm the General Counsel for the Personnel Cabinet.
And what was your name, sir?
It's Gordon Rowe. I'm the General Counsel for the Personnel Cabinet.
Yes, sir. Thank you very much. Mr. Rowe, Mr. Hurst, and Ms. Holbrook, we appreciate you taking time today from your schedule to be with us on this discussion of this. I'm going to go to you first. Is there anything that you would like to comment on, or any statements that you would like to make before we go to questions specifically on this regulation?
No, I don't think there's anything initially that we want to comment on, other than we look forward to answering your questions and hopefully being helpful in response to some of the issues that may be raised by this regulation.
All right. Thank you very much, sir. We do have several I'm sorry. Go ahead, please. Okay. Once that you speak, please mute your microphone, or we're getting some feedback here in the committee room. Either of the other two have anything you'd like to add, or you want us to go to questions right now?
No, sir.
Okay, thank you. We do have some questions from some of the members, and I am going to yield first to Senator Adams, which has some questions that she would like to proceed with. So, Senator Adams, please go right ahead at this time.
Thank you. I appreciate you all being here to answer my questions. As you know, I wrote you a letter dated November 5th inquiring as to the inclusion of the Child Victims Trust Fund in the Kentucky Employees Charitable Campaign, and I never heard anything back. So fast forward, we put this regulation on the agenda for today, and magically I heard back from you all as to why we could not include the Child Victim Trust Fund in this employees charitable organization. And I guess I would just like for you to state for the rest of the committee, before I get to my ask, which is, can you change your regs so that we can include this particular organization in the employees' charitable giving? I don't know who wants to take that. Your justification.
I'll take that, Senator. And first, let me apologize for the delay in our response to your letter. It was not because we didn't feel like this response was not important, and it wasn't magical. We'd actually sent a response a few days before that. I emailed that response to you on Friday to make sure you had it before this meeting, but I suspect the other one is in the mail. To the substance of your question, we do not believe we can change the regulation without more facts. I mean, the basis of the regulation and the basis of us denying the Child Victims Trust Fund inclusion in KACC up to this point has been looking at the letter of this administrative regulation, which says it has to be a 26 USC 501c3 organization. And as stated in the letter, what 26 USC 501c3 allows is not only for the organization to be tax exempt, but also that the deductions to that organization are tax deductible. And we didn't have enough information from the Child Victims Trust Fund to determine that deductions to it would be tax deductible. In fact, the information we had suggested that those donations would not be tax deductible. And that's essentially the reason that we had denied inclusion for the Child Victims Trust Fund into the KACC campaign. We do believe certainly that this fund and the work that they do is very important to the citizens of Kentucky, and we support their work fully. But the language of that regulation and the underlying ability for those deductions to be tax deductible prevented us from doing that.
Okay, and so I guess that is, I will follow up with my ask, which is, would you be willing to change your administrative regulations to allow the Child Victims Trust Fund to be covered under the Kentucky Employees Charitable Campaign?
We would be willing to try to work with them and get more information to see if that's possible. One of the things suggested in your letter was that we expand inclusion to other nonprofit tax-exempt organizations, and we didn't want to go that far because, again, there are tax-exempt organizations such as 501c4 organizations, which are tax-exempt, but because of their status of being able to advocate on behalf of political candidates and other things, the deductions to those organizations for our employees would not be tax deductible. So we'd have to do some more research to find out that were possible, but we're certainly willing to work with the Child Victims Trust Fund to see if that's possible.
Okay, I appreciate that response because, the emotional answer is that how would you not allow for state employees to want to contribute to a fund of kids who have been raped and sexually abused? Why would we want to eliminate state employees who sometimes this is their biggest issue that they advocate for? Why would we want to eliminate that ability for them to participate in something that's so important? As you know, Kentucky is #1 in child abuse and neglect for the last 3 years. We're going to be there on #4 if we don't start to change that mindset. And so the way that the statute did not allow for the personnel cabinet to come up with this Kentucky Employees Charitable Campaign. This was something that was identified and created by the personnel cabinet. It was a very broad purview that you all had in order to create this. Yet you seem to be very narrowly focused on who's allowed to participate and who our employees are allowed to contribute to. And so I'm encouraged by your answer that you will keep an open mind on something that's this important. because Kentucky really needs to change the dynamic in which we're going. And it might start right here and with this. And
Senator,
yes.
I'm sorry.
No,
Sorry, go
please.
So we certainly agree that this is a very important issue. It's a very important organization. They do great work. From everything that I've read, they do great work in terms of informing citizens about this very important issue. So I don't want that to be misconstrued at all. I will say there are other organizations that haven't met our criteria for other reasons that also do very good work, but haven't met the criteria and have not been able to be part of the KECC campaign. That being said, there are certainly other avenues for employees to contribute, and we certainly would not dissuade any employee from contributing to this worthwhile cause. But
Can I ask
we
a
are
question?
to work with the Child Victims Trust Fund to see what can be done on this specific
So one more question based upon your answer. You said that there are other organizations that have not met your criteria. Have those organizations that have not met your criteria been established in statute? Because the Child Victims Trust Fund has been established in statute.
Right, I understand that, and I can't tell you. I can't tell you that I did an exacting historical analysis of all the organizations that have been denied since the KECC was established. So I can't say which ones were or were not. But
well, you're the one that brought it up, and so I'm just curious if those that you've denied have been established in statute by the General Assembly.
I'm not sure. I only brought it up just to say, Senator, that the purpose of the organization is not the reason we denied it. That's the only reason I brought that up.
Okay. Well, I look forward to working with you so that we can both hopefully come up with an agreeable solution to this problem.
I look forward to it as well.
Thank you, Mr. Chairman.
Thank you. Senator Alvarado.
Thank you, Mr. Rowe. Just curiosity, you said you're not sure about if donations to the Children Victims Trust Fund are tax deductible. Is that correct?
That's correct.
What kind of research have you done in this regard?
I've looked at the annual reports from the Child Victims Trust Fund. I've looked at their organizational documents, and I've looked at the other information that they submitted to us as part of their application to become part of the Kentucky Employees Charitable Campaign.
I'm looking at their website. I've got my phone here. You may want to pull it up on your computer. I've looked up Child Victims Trust Fund, Kentucky.gov, and it's got how we help, license plates, and then it has a button that says donate. When I hit donate, we welcome your tax-deductible donations. You may donate online by clicking this link or by sending a check to Office of Traffic and Abuse Prevention and Prosecution, CVTF Program Administrator. Some of the research you may want to do is just to look on Google and do a search on their website and take a look at what they claim to be, because if not, if we have a government organization claiming tax-deductible donations and they're not that way or allowed to, that's a major concern, obviously, I would think. But that's all I'm doing here. I haven't done any research on this. This is presented before us. I'm just looking on my phone. And when you click on How We Help on their website, it talks about their current tax status. They're a nonprofit organization that the Child Sexual Abuse and Exploitation Prevention Board announces the availability of grant funding, and it talks about their current structure. So it might be worth to actually look as if the situation is that they're claiming to not allow it, they're not allowed to do that, and they're advertising that, someone's violating the law somewhere along the line within the administration currently. So I'd recommend that maybe you look at their website to see, to find out, because that's what they're claiming. If people donate money, they're assuming they're getting a tax-deductible donation, and they're probably claiming that on their taxes as well. And to say that they're not getting that, you might want to talk to the attorney who's in charge of their website, because that's a government agency that's being there as well. Is there anything in state or federal law that prohibits you from allowing the Child Victims Trust Fund into the KECC?
No, to my knowledge, no. There's nothing that prohibits us from doing that.
So is that something you're willing to do? I mean, I think there's a lot of will within this committee. I mean, that would be something I think would be worthy of a regulation change. Nothing prohibits you from doing it. Change the regulation to allow this to come into play.
Well, what we're trying to do, Senator, is to try to structure this regulation to also maximize the benefit to our employees. So that's why we wanted those donations to be tax deductible, and that's essentially why it's structured in the way that it is. But as I said, we're willing to certainly try to work with them to see perhaps there's information that we don't have, and we're willing to work with them to see what we can do.
Yeah, Google Child Victims Trust Fund. You'll look at it right there. That's what they're. When you try to donate, it says that their donations are tax deductible. Thank you, Mr. Chairman.
Thank you, Senator. The next question is going to come from Senator Yates. Senator Yates, go right ahead, sir.
Thank you, Mr. Chair. I appreciate that. And my colleagues, thank you for bringing this up. Very, very important issue in Kentucky. In fact, I cut my teeth in public service dealing a lot with this. I was on Megan's law team, and we did a lot of prosecutions going to it. One thing I found, though, is sometimes get the result is simpler. Is there a way that right now trying to get money from the public employees directly to the trust fund seems like it's been an issue because of law created, and I understand why. Looking at the history of that, I guess in 2002, trying to make sure that you're not the public employees are also asked to pay for some of the things they service, and I know I can think of other examples where that become problematic. But can we use pass-throughs to get through to them? And sometimes that looks like a oh no, but just also Googling while I'm looking at it. If you pull up, I guess we have the Prevent Child Abuse Kentucky. Prevent Child Abuse is nationwide. It's huge. The money comes from all over. And I know that Kentucky, because we do make some headlines because of all the levels of abuse and neglect that we have, we get some outside money. Is there a way that we could partnership with the trust fund with, the PCA, KY, and potentially be able to stream it that way? We don't violate the law as it is, and we still make sure we get those funds and money to the very asset in which we're trying to help, and that's the children. So I know I've done that to when I used to be president of the city here locally in Louisville. We find ways. I want to make sure that there was appropriate checks and balances and oversight, and some of my smaller ones didn't have that, so I wanted to make sure that was put in place. But if we had Prevent Child Abuse Kentucky, that could be the option, and long as there was an understanding agreement that they were going to, whatever percentage of money they get in, make sure it goes back to the trust fund to be able to carry out the same goals. We got two different parties doing similar situated goals. Does that not achieve the same result, which is hopefully reducing neglect and abuse? I think I don't want to undermine maybe some of the problems that we have with it, but I was just trying to think of a very quick solution and result that we could do to try to negate this bad issue. So I didn't know if there was anything in place to keep that from happening, that potentially that the trust could partner with Prevent Child Abuse Kentucky or one of the other 501c3s that would be registered appropriate, put some kind of agreement together, and that way that they could be put on the list and it would achieve the same results with knowing that 100% of those money given would go to that very issue.
We'd certainly be willing to look into that as a possible avenue to do that. That may be a way to structure this to have that done a little more quickly without changing the regulation or having new legislation have to be passed to do that.
And you have twice as much oversight as well, because you have both of them having to submit back to us.
Thank you, sir.
I think Senator Alvarado wants to comment again, and I think he has a comment based on that question that was just brought up there.
Yeah, thank you, Mr. Chairman. The Child Victims Trust Fund already has a partnership with Prevent Child Abuse Kentucky. So the trust fund's actually a pass-through to fund services provided by the Prevent Child Abuse Kentucky. So it's already in place.
So it works then. They could give directly to the Prevent Child Abuse Kentucky and just work in the reverse. Is that correct?
I'm not sure about that. But okay. that might be I'm not sure though, and I can't speak on that definitively.
Okay, thank you, Senator.
Senator West.
Thank you, Mr. Chairman. My understanding that my question is going to center on the authority. What authority you have as a cabinet, and it's my understanding you're using your all's authority under 18A.030. to promulgate regulations in this space. Is that accurate? Is that correct?
Yes, that's correct.
Okay. So when I look at 18A.030, it says the secretary shall as provided by this chapter, promulgate comprehensive administrative regulations consistent with the provisions of KRS Chapters 13A and 18A for the administration of the personnel system. So in other words, you're relying on the general authority given in that statute to do this. It's pretty wide. Is that a fair statement?
Yes.
Okay. So through that wide latitude is what was used to put this into place in the first place. And so the cabinet, when they promulgated this reg, you all are the ones that put in the requirement of 26 USC 501c3. Is that correct?
That's correct. This is to my knowledge, yes.
Okay. So I think it's safe to say, because you've had the wide authority and you've used that authority, that you can also use that wide authority to craft language to include the trust fund pretty easily. So I think there's kind of a consensus here that's the wish of the committee, that you would basically work this out with the Attorney General's office and come up with that language. And, we would have oversight of that language. So whatever language it was, it would have to come back through this committee, and we could work it out then. So my ask is that you do that. Now, I'm assuming that's what you probably were going to do anyway, but that's my official request is what happens.
Thank you, sir. As I said, we will definitely go back to the Child Victims Trust Fund and try to work with them and see what we can craft to make a solution possible.
Thank you.
Are there any more questions or comments, please? I would just close by saying this. First, I want to just say thank you all very much for appearing with us today. We appreciate your answers on these questions that were brought by the committee members. I'm very encouraged to hear of your willingness to work to rectify this situation. As we've heard the committee members and then your responses to their question, it appears that this can happen. So as this committee look forward to language that would come back to us to change this regulation, we're looking forward to that. And I also just want to add this. I want it to be more than just you telling us that that's your willingness to do this. We need to make this happen. We need to make this happen, because I think the only thing I would correct Senator Adams on, I think we're not fourth from the bottom. I think we are the bottom. If my research was correct, I think we're 50th in the nation. And so I think this is such an important issue. And again, I appreciate your willingness to work with us. Representative Bridges, would you like to have a question, please?
Yes, Mr. Chair.
Yes, sir. Please go right ahead.
Just a suggestion. Sitting here looking at the website Senator Alvarado brought up, it doesn't take but one or two clicks to find that this site is formed by the Office of the Attorney General. I think the simplest thing is we've got two government organizations. How about picking the phone up and calling the Attorney General and find out exactly how this is set up and why has not? I just can't believe that hasn't been done. That'd be the simplest, straightforward shot of connecting the dots and getting the information that's needed. And if he's not qualified to give us the proper information, I don't know if we've got anybody in the state that is. Because it says on this website, Office of the State Attorney General. So I would suggest picking the phone up and calling over there. That may cut a lot of this government bureaucracy out of this and getting right to the point. Thank you, Mr. Chair.
Thank you, Representative Bridges. Again, I believe the consensus of all the committee here today and you folks that are with us is we want to make this happen, and so let's make it happen. We would love to have this in a regulation that would allow what we're talking about here today to happen. So again, I do want to say thank you for being with us. I appreciate your time and your response to this. And anything else, sir, you'd like to say before we move on?
No, sir. Thank you for your time.
All right. Thank you all very much. Please call the next regulation at this time.
Education and Workforce Development Cabinet, Education Professional Standards Board, 16 KAR 1030 with amendment.
This regulation amends to add sections clarifying the superintendent's duty to report requests for a private hearing, and motions to reconsider, to make corrections in accordance with KRS Chapter 13B and make minor updates. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS 13A.
Would you please identify yourselves today for the record?
Good afternoon. Cassie Trueblood, Counsel for the Education Professional Standards Board.
Thank you very much today for being with us. There is a staff amendment on this regulation. Is there a motion for approval of this staff amendment?
Motion.
There is a motion. Is there a second? There is a motion and second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee on this regulation? There appears to be no questions. Thank you, ma'am, for being with us today. Please call the next regulation at this time.
Under Secretary of State, Office of Business Services, 30 KAR 5011 emergency, 21 emergency, 31 emergency, 41 emergency, 51 emergency, and 60 emergency. These do not have additional amendments.
This package of regulation establishes filing procedures for secured transactions under the Uniform Commercial Code.
Good afternoon. Would you please identify yourself for the record today?
Good afternoon. This is Michael Wilson. I'm the Director of Business Services for Secretary of State Michael Adams.
I'm Jonna Ballinger.
Yes, push your button there.
Yes, hi. I'm Jonna Ballinger, Administrative Section Supervisor of the Records Section overseeing UCC.
Thank you very much. We appreciate your time being here with us this afternoon. There are no amendments to this set of regulations. Are there any questions from members of the subcommittee? Senator West has a question. Go right ahead, sir.
Thank you, Mr. Chairman. I try not to ask any questions as it pertains to UCC filings, but in this case, what's the reason for the emergency on the
The Uniform Commercial Code requires us to maintain these regulations, and due to an oversight, the previous set of regulations expired under the Red Tape Initiative.
Okay. Thank you. That's all I need.
Any other questions or comments? There appears to be no further questions, so thank you all again today for being with us. Please call the next regulation at this time.
Personnel Board, 101 KAR 1 335, 345, 365, 367, 375, 395, and 400, all with staff suggested amendments.
101 1 335 through 400. Amend Personnel Board provisions including workstations, demotions, promotions, transfers, reinstatements, reprimands, disciplinary actions, hearings, appeals, board proceedings, grievances and complaints, and restoration of employment from military duty to make technical corrections, clarify provisions, establish that a disciplinary fine shall not conflict with federal requirements, and streamline procedures for filing related to appeals or hearings. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself today for the record?
Good afternoon. Stafford Easterling, General Counsel, Kentucky Personnel Board.
Thank you, Mr. Easterling. Anyone else?
No, I will be here representing the board for, I'm afraid you have to deal with me, I'm afraid.
We're fine with that. I just had two people on my list, and I was just making sure that I wasn't before we got everyone introduced. But again, thank you, sir. There are staff amendments to these regulations. Is there a motion for the approval of the staff amendments? There is a motion. Is there a second? There is a motion and second. Without objection, it is so ordered. Are there any questions for Mr. Easterling from the members of the subcommittee? Mr. Easterling, it looks as though you have no questions today. So again, we appreciate your time for being with us today. Please call the next regulation.
Boards and Commissions, Board of Cosmetology, 201 KAR 12082, emergency and ordinary, both with staff suggested amendment.
201 KR 12082, ordinary and emergency, both amend to add the phrase of any practice listed in KRS Chapter 317A or 201 KR Chapter 12 in multiple places throughout the regulations, specifically in reference to schools or programs of instruction to be approved by the board. include a new section related to alternative education delivery methods that may be approved during a world health concern or crisis to be approved by the board, and for which the board may determine when the emergency alternative education shall begin and end, and specify brand name technology options for remote learning. The emergency amended after comments version for 201 KR 12082E requires Malady or Pivot Point supported digital curriculum platforms. The staff amendments for both regulations amend various sections for clarity and consistency with statute, and to change language to any practice licensed or permitted in KRS Chapter 317A or 201 KR Chapter 12. Amend Section 33 to include compliance with state and national declarations of emergency, and amend various sections to comply with KRS Chapter 13A. Additionally, the staff amendment for 201 KR 120820 amends Section 33 to require Malady or Pivot Point supported digital curriculum platforms for consistency with the emergency amended after comments regulation.
Good afternoon. Thank you for being with us today. Would you please identify yourself today for the record? Would you please push your button till the green light comes on?
I'm sorry, it was on. I thought it was. Julie Campbell, the Kentucky Board of Cosmetology Director.
Welcome, Ms. Campbell. We're glad to have you with us in person today.
Thank you, sir.
There are staff amendments. Is there a motion for the approval of the staff amendments? Second. There is a motion and there is a second. Without objection, it is so ordered. Ms. Campbell, anything you'd like to add today?
No, sir.
Are there any questions from any of the members? We appreciate your time. Thank you for your being with us this afternoon. Please call the next regulation at this time.
Tourism, Arts and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 2082, 301 KAR 3010, and 026, all with staff suggested amendments.
301 KAR 2082 amends requirements for the development of an online permitting system, amends the expansion of the department's ability to deny or revoke a permit, the prohibition on the importation and possession of wild rabbits, hares, pikas, fox, Komodo dragons, and lynx species, the improvement of protections from rabies, the authorization of certain exemptions, inspections and other permits, administrative hearings, confiscated wildlife, grandfathering for previously held legal prohibited wildlife species, and the establishment of permit applications and report forms. The staff suggested amendment amends Section 10 to specify that the Commissioner's decision to revoke an exemption or deny future exemptions shall be based upon the necessity to protect public health, public safety, native ecosystems, or native wildlife, and various sections to comply with KRS Chapter 13A. 301 KAR 3010 and 3026 amend to make technical corrections and update language. The staff suggested amendments for these regulations also amend various sections to comply with 13A.
Thank you very much. We welcome Fish and Wildlife today with us. Would you please identify yourself for the record at this time?
Thank you, Mr. Chair. My name is Brian Clark. I'm Deputy Commissioner for the department.
I'm Stephen Fields, Staff Attorney for the department.
All right. Thank you, gentlemen, Mr. Clark, Mr. Fields, for being with us today. There are staff amendments to the regulations that were given to us. Is there a motion for approval of the staff amendments? There is a motion. Is there a second? There is a second made. Without objection, it is so ordered. Are there any questions from the members of the subcommittee? I generally am the one that will bring up a question concerning fish and wildlife. I really do not have any questions except one. I do have a small question on the 301 KER 03026 about the access to the wildlife management areas for the mobility impaired individuals. What is actually being done to provide them the opportunities for that? Could you just give me just a real quick answer on that? What's actually being done for that? For those
Sir, we have designated tracks on wildlife management areas where people with mobility impairments may obtain direct access using a vehicle. And so it's not on every WMA or every tract, but we have designated areas in each region so that people with impairments can access the WMAs using an ATV or a vehicle.
Okay, so they can actually ride one onto the wildlife management areas.
Yes, sir. They can use those as both a means of transportation to and also a hunting platform in a WMA.
Is clay management area included in that?
I'll find that out for you, sir. I don't remember off the cuff, but we'll find that out and report back to you.
Thank you. Appreciate that. Any other comments or questions? Thank you all very much for your time. Please call the next regulation today.
Thank you.
Thank you.
Transportation Cabinet, Motor Vehicle Commission, 605 KAR 1051, 71, 91, 131, 191, and 211, all with staff suggested amendments.
605-1051 establishes the rules of conduct for motor vehicle dealers and salespersons licensed under KRS Chapter 190. 1071 establishes the procedures for motor vehicle dealers to report ownership status to the Motor Vehicle Commission and the requirements for notification of change of ownership. 1091 establishes provisions against false or misleading advertising on the part of a motor vehicle dealer. 1131 establishes forms of procedure and practice for hearings conducted by the Motor Vehicle Commission. 1191 establishes examples of what constitutes false or misleading advertisement. And 1211 establishes procedures for application and licensure for nonprofit motor vehicle dealers, including the disadvantaged nature or condition of clients served. The staff suggested amendments to these regulations amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself today for the record? Do we have anyone from the Motor Vehicle Commission that's joining us today? If you're muted, if you are with us, you might still be on mute. We're going to proceed on to the next regulation.
Education and Workforce Development Cabinet, Board of Education, 702 KAR 1191, with a staff suggested amendment.
This regulation establishes paid quarantine leave for employees in response to exposure to a reportable disease. The staff amendment amends various sections to comply with 13A drafting requirements.
702 KR 7065 amends to make changes to material incorporated by reference, including the bylaws, to comply with recent legislation that permits students to repeat the 2020-2021 school year under certain circumstances while still remaining eligible to compete in the interscholastic athletics. Make changes as a result of the recent annual meeting of member schools where they voted to clarify the procedure to break ties when voting for a member of the Board of Control that is contained in the KHSAA Constitution and update policies and other documents according to recent board action. The staff suggested amendment amends Section 1 to comply with KRS Chapter 13A.
And along with the first regulation, we also have 702 KAR 7065, also with a staff suggested amendment.
All right. Thank you very much. Would you please identify yourselves today, gentlemen, for the record?
Good afternoon. Todd Allen, General Counsel for the State Board of Education and Department of Education.
I'm Julian Tackett, Commissioner of the Kentucky High School Athletic Association.
Chad Collins, General Counsel for the Kentucky High School Athletic Association.
Thank you all, gentlemen, for being with us this afternoon. There are staff amendments to these regulations, both of these regulations. We are doing them together, correct? Okay. For both of these regulations. Is there a motion for approval of the staff amendment? There is a motion. Is there a second? There is a second that has been made. Without objection, it is so ordered. Are there questions from the members of the subcommittee today for our guest? Senator West, go right ahead, sir.
Yes, my question is for Mr. Allen. What is the current quarantine period for our schools? Do you know?
So for school staff,
yeah.
The most recent CDC guidance, as I understand it, that has been released is that it's 5 days. After a 5-day period, the employee would return wearing a mask for another 5 days, but could return at that period in time.
So does this reg, do those two things jive? Do we say the quarantine period is officially per CDC guidance, or do we say it's 5 days, or how does that?
So, Senator, I think this regulation, it isn't tied to any particular CDC guidelines. So as they may change going forward, this would also jive with that. And also this regulation isn't particular to COVID-19. So it will continue on once we move beyond, hopefully soon, the COVID-19 pandemic. So this
I guess my question is what, we're basically through this reg, we're going to be paying staff, teachers and staff for the time that they're quarantined. That's correct, right?
Yes, up to a total of 10 days. It's time limited.
Okay, so that was my real question. So are we gonna pay them for 10
Excuse me,
days?
Senator, could I someone is not muted on their mic. We are getting some feedback in our committee room. I apologize for interrupting, Senator, but we need someone to mute your mic, please.
Thank you, Mr. Chairman.
Pardon me, Senator West. Proceed. My apologies.
No problem. Thank you. So are we going to have a scenario where someone is quarantined for 5 days, then they're back at school working and getting paid for 10 days? Or it'll just be the period they're officially out?
That's right. And the conditions around that are, first of all, it has to be a reportable disease that's defined by the Department for Public Health. The employee has to be ordered by their treating physician that they need to be under quarantine as a result of that. And they have to have either exhausted their accumulated sick leave or be ineligible for the use of that sick leave. So this is really a situation to provide some safety net for those who don't have sick leave or who otherwise would be returning to work but have been told they really ought not to.
And it's a good clarification. So just didn't know, needed more information. Appreciate that.
Thank you, Senator. Any other comments? Representative Frazier Gordon.
Hi, thanks for being here today. And this question is also for Council Allen. Are vaccinated and unvaccinated employees being treated equally in this reg?
So this regulation isn't specific to COVID-19, so
Okay.
it doesn't speak to vaccinated versus unvaccinated status. The employees would be treated the same under this regulation.
Okay. And may I ask a follow-up?
Yes, please go right ahead.
So it's my understanding that are the absentee policy being implemented under 192E at the moment?
Mm-hmm.
And could you speak to that regulation? Does it differentiate between vaccinated and unvaccinated?
It does. So that one is specific to COVID-19. It will expire when this regulation becomes effective, and this one will carry forward. The emergency regulation does make a designation between vaccinated versus unvaccinated employees. So those vaccinated employees, I don't have it in front of me, I apologize since it's not on the agenda, but as I recall, those vaccinated employees are eligible for the paid leave, whereas unvaccinated employees are not eligible for that paid leave.
Okay, but
under the emergency, not
okay, but
this
to
regulation.
reiterate, this one will take the place of the other one once it goes into effect.
That's correct.
Okay, thank you for being here today.
Mm-hmm.
Any other questions? I'm going to change direction just a little bit and go to Commissioner Tackett. Commissioner, thank you for being here with us today. I know it's been a difficult time for the KHSAA the last 2 years. Anything that you would just like to inform us as the committee of how things are going? Are we having much difficulty right now? I mean, just quick synopsis, if you might, please.
Thank you, Representative Hale. It's always good to see you.
Thank you, sir.
And all of you. Actually, our schools have done a tremendous job of trying to navigate the balance between what's going on in public health and the mental health issues with depriving the kids of being able to play. And they've really juggled well. Different locales have handled it different ways, and it all seems to be working. The kids are getting the opportunity to participate. We are going to try to recruit people such as yourself to come back out to officiate, because where we have lost people is in the officiating in all the sports. We're down about 25% over 2 years, and that's going to be a challenge in the near future. But for right now, we're still able to play, and I think between you and Representative Bridges, we got 2 more we can line up.
Well, I thank you for that comment, sir. I think my limited abilities may be just to toss the ball up and then kind of work the center line. If there's over and backs, I think I could handle that from that one spot there. But I do appreciate what you're doing as a commissioner, and I know it's been difficult. And again, I know this is outside of this committee, but we are addressing that situation with our officials, and hopefully we can come up with some answers on that. Any other questions or comments? There appears to be none, so thank you all very much today for your time. Please call the next regulation at this time. Okay, we're going to backtrack to the Motor Vehicle Commission. So if you're looking in your booklets, please go back to under the Transportation Cabinet, and we'll proceed with that one.
It's the Title 605, Chapter 1s, and they all have staff suggested amendments.
Okay, so we've already read the summary, correct? Okay. All right. Would you identify yourself, please, at this time?
Yes, sir, Chairman Hale. My name's Carlos Cassidy, Executive Director of the Kentucky Motor Vehicle Commission. I had trouble getting unmuted earlier.
That's all right, Mr. Cassidy. I have trouble with that all the time, sir. So thank you for being with us today. There are staff amendments on this set of regulations. Is there a motion for approval of the staff amendments? There is a motion and a second. Without objection, it is so ordered. Are there any questions from any of the members? Mr. Cassidy, there appears to be no questions. We do thank you for coming back and being with us. Please call the next regulation.
Thank you, sir.
You're welcome.
Department for Libraries and Archives, 725 KAR 1, 10, 20, 25, 30, 40, 50, 61, and 725 KAR 2, 015, and 080. All except 725 1025 have staff suggested amendments.
725 1010 through 2080 amend libraries and archives provisions including records officer provisions, record reproduction, retention, management, and transfer, requirements for records collection and distribution, provisions for public library facilities construction, and requirements related to the Interstate Library Compact to make technical corrections. Additionally, 1040 updates definitions and provides for electronic distribution of reports and publications. 1050 deletes outdated requirements, and 2015 clarifies state librarian appeal procedures. The staff suggested amendments amend various sections to comply with KRS Chapter 13A, including material incorporated by reference. 1050 establishes an informal appeal process, and 2080 establishes which parties shall use the incorporated material.
Would you please identify yourself today for the record at this time?
Yes, good afternoon. My name is Terry Manuel. I'm a commissioner for the Department for Libraries and Archives.
I'm Beth Milburn, the Deputy Commissioner for Kentucky Libraries and Archives.
Thank you both for being with us this afternoon. Appreciate your time. There are staff amendments. Is there a motion for the approval of the staff amendments? There is a motion. Is there a second?
Second.
There is a second. Without objection, it is so ordered. Are there any questions from the members of this subcommittee at this time?
I got a question.
Senator West has a question. Senator West, go right ahead, sir.
Thank you, Mr. Chairman. Is there anything in these regs that would speed up the process for the disposal of public records? Like it would speed up the time frame?
These regs don't address record retention, if that's what you're referring to. That is a process that goes through the State Libraries, Archives, and Records Commission, and records retention is decided in conjunction with the agencies in which it impacts. And sometimes often legal considerations have to be taken into account about how long a record needs to be kept. But generally, a record is kept just as long as it meets the legal requirements and the needs of the agency. The State Libraries, Archives, and Records Commission doesn't arbitrarily set retention periods.
Yeah, you answered my question. So this has nothing to do with that, really. I mean, that's all set at the agency level.
That is set in cooperation with our department at the agency level, and determined by the Libraries, Archives, and Records Commission.
Okay. Thank you.
Any other questions? Thank you all again for being with us today. Please call the next regulation.
Public Protection Cabinet, Department of Alcoholic Beverage Control, 804 KAR 4221 with staff suggested amendment.
804 KR 4221 establishes requirements relating to a licensed premises being shared by two or more licensees through an alternating proprietorship agreement, including to define the type of agreement, establish the basic requirements for this type of agreement, prohibit an alternating proprietorship agreement if it would create an interlocking interest, exclude direct shipper licenses, and direct compliance with any applicable federal laws. The amended after comments version removes the prohibition against an alternating proprietorship agreement, creating an interlocking substantial interest, and inserts a prohibition against an alternating proprietorship agreement with any person who holds a Kentucky alcoholic beverage license that the other licensee cannot hold under Kentucky law. The staff amendment amends various sections to comply with KRS Chapter 13A.
Thank you very much. Would you please identify yourself today for the record at this time?
Yes, my name is Joshua Newton. I'm the General Counsel for ABC.
Thank you, Mr. Newton. We appreciate you being with us today. There is a staff amendment to this regulation. Is there a motion for approval of this? There is a motion. And there is a second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee today for Mr. Newton? Senator West, go right ahead, sir.
Sorry, Mr. Chairman, I'm just full of questions today.
No, sir, that's what we're here for.
What is the problem that this regulation seeks to solve? I guess I'm having a problem seeing.
I'm sorry, I can't quite hear you.
Okay, no problem. I'll restate that. What, if you could tell us, what particular problem is this regulation seeking to solve?
Okay, so my understanding is actually that this sort of arrangement has been requested for a number of years, and it is something that the TTB recognizes. Essentially, the problem that you run into is there are a lot of distilleries and other sorts of producers that may want to create and produce alcoholic beverages, but do not have the capital to build a distillery on their own or build a brewery on their own or something like that. So this allows a number of basically brand owners to come together and potentially pool resources to create or use one premises, so long as they all are able to meet the requirements to with how much they produce or are required to produce under their license. They can each use it individually in order to sort of build their brand enough to where they could potentially start their own without others or something like that.
Yeah. Okay, so are these arrangements like causing a problem?
Are these arrangements what? I'm sorry?
Are these arrangements causing a problem to the general public, or what? Why are we?
Currently, they aren't allowed. They haven't been. They have not been interpreted to be allowed under the law. But that's the understand. That was just an understanding based upon one way that the law could be interpreted. This is taking that in a different direction. Well within the law, but making it official that this is a legal arrangement.
Okay. So we're basically, I guess I misunderstood this. We're allowing these arrangements. Through this regulation, we're now officially allowing these arrangements?
Yeah. Through this regulation, we would be allowing the sharing of the premises.
Okay. I'm sorry, I totally misunderstood. I thought it went the other way. I thought we were prohibiting. I apologize. Thank you.
Understood.
Any other questions? Thank you very much, sir. We appreciate your time. Please call the next regulation at this time.
Department of Insurance, 806 KAR 12010 and 806 KAR 14007, both with staff amendments.
806 KAR 12010 amends to clarify regulation is limited to a life or health insurer issuing a policy as defined in Section 3, and that the regulation applies to individual and group accident and sickness insurance advertisements and to incorporate a form by reference. 806 KAR 14007 amends to incorporate an updated form and address fee filing inconsistencies with other regulations. The staff suggested amendments for both of these regulations amend various sections to comply with 13A.
Would you please identify yourself today for the record at this time?
Good afternoon, Abigail Gall for the Department of Insurance. I'm one of the regulations coordinators here, and then we have one more person on.
Good afternoon, Chad Thompson, General Counsel with the Department of Insurance.
Sean Orm will not be joining us. He was on our list. We had a internal meeting pop up today, so it's just going to be the two of us today representing.
All right, thank you very much, both of you. There are staff amendments to both of these regulations. Is there a motion for approval? There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Are there any questions from the members of this subcommittee? Appearing to see no questions, thank you all for your time. Please call the next regulation.
Thank you.
You're welcome.
Department for Housing, Buildings, and Construction, 815 KAR 35020. There are not additional amendments.
815 35020 amends requirements for inspections of electrical construction installations, alterations, and repairs to exempt electrical work performed beyond the service disconnect by or on behalf of the Transportation Cabinet by pre-qualified contractors within the public right-of-way and not related to occupied buildings.
Would you please identify yourself for the record this afternoon?
Good afternoon, Benjamin Siegel. I'm the General Counsel for the Department of Housing, Buildings, and Construction. And I'm joined this afternoon by Commissioner Rick Rand, Daryl Morgan, who's the Director of our Electrical Division, and Jason Sawula from the Kentucky Department of Transportation.
All right, thank you all very much. There are no amendments. Are there any questions from the members of the subcommittee? Any of the members? It appears there are no questions. Thank you all for being with us today. Please call the next reg at this time.
Thank you.
Cabinet for Health and Family Services, Office of Telehealth Services, 900 KAR 12005 with an agency amendment.
900 12005 establishes terms and provisions for telehealth, including requirements to protect confidentiality. At the December 9th meeting of this subcommittee, suggested amendments were approved to amend various sections to comply with KRS Chapter 13A. The agency amendment amends Section 2 to make a technical correction and delete subsection 1E, which required guidelines to contact, refer, and obtain treatment for a patient who needs emergency or higher level of care services. These same amendments were approved for the emergency version of this regulation at the December meeting of the Interim Joint Committee on Health, Welfare, and Family Services.
Would you please identify yourself today for the record?
Hello, I'm Donna Vino, the Division Director.
I'm Kim Minter, the Staff Assistant with ODA.
Kelly Rodman, Cabinet for Health and Family Services, Legislative Affairs Director.
All right, thank you very much for joining us today. We had a lot of discussion on this specific regulation last time. I know Senator Alvarado had a lot of questions. Before we proceed with questions, there is an agency amendment to this regulation. Is there any discussion on the agency amendment? Senator Alvarado has some discussion or a question on the agency amendment.
More just a comment.
Okay, go ahead,
I want to thank you all for the changes you've made. I know this was kind of brought before our health and welfare with the emergency reg where the changes were made. So this makes it much better. A lot of the concerns we had, I think were addressed. And I think the Cabinet went and got some feedback from Board of Medical Licensure and well, and a lot of people said, yeah, that needed a change. So I want to thank you all for the changes. I would make a motion to accept it.
Yes, there is a motion. There has been a motion on the agency amendment. Is there a second? There is a second. Without objection, it is so ordered. Are there any questions now on the regulation itself? There appears to be no questions, and I would just like to add to Senator Alvarado's comments. We do thank you very much for your cooperation and the changes that were made. We very much appreciate that, and again, thank you for working with that on that with us. We appreciate it very much. Again, thank you all for being with us. There are no other questions or comments. Please call the next regulation.
Thank you.
Office of Inspector General, 902 KAR 20081 and 460 emergency, and also 906 KAR 1180 with staff suggested amendment.
902 KAR 20081 amends provisions to comply with new legislation which concerns dementia-specific training requirements for home health aides and which allows advanced practice registered nurses and physician assistants to supervise home health services. 902 KAR 2460E establishes guidelines for implementation of essential personal care, essential compassionate care, and end-of-life visitor programs in long-term care facilities during the COVID-19 pandemic in accordance with new legislation. 906 KAR 1180 amends provisions to comply also with new legislation concerning dementia-specific training for direct care staff members and to update provisions relating to the requirement for personal services agency staff to submit to a check of the Adult Caregiver Misconduct Registry. The staff suggested amendment to 906 KAR 1180 amends to transfer language from Section 1 to Section 7 and various sections to comply with 13A.
Would you please identify yourself for the record today, whomever's joining us?
Hi, Adam Mather, Inspector General for the Cabinet for Health and Family Services.
Kara Daniel, Deputy Inspector General for the Cabinet for Health and Family Services.
Thank you both today for your time in being with us today. There is a staff amendment for this regulation. Is there approval of the staff amendment? There is a motion. Is there a second, please? There is a motion and a second. Without objection, it is so ordered. Do we have any questions from the members of the subcommittee? Senator West has a question. Go ahead, sir.
Thank you, Mr. Chairman. My question pertains to 902 KAR 020460E, the Essential Visitor Programs. My understanding is these are regulations born out of statute passed in the special session, and I think this is just a very, very important area. Could you quickly go through what these regs actually end up doing as far as visitation?
Yeah, we can quickly give you a scenario. They will allow, they will deem specific individuals to be characterized as essential caregivers, and if there ever is a time where visitation would be shut down, they would have access to those individuals through this regulation.
And so, as an example, who would some of those people be?
If there is a let's say there's a patient, a family member comes daily to take care of them prior to any issue, they would be able to continue doing that through this pandemic if needed.
So it's not laid out as if close family members. It's not set up in that way. It's not set up as
no,
close.
They're already. Yeah, sorry, I didn't mean to.
Go ahead.
I was going to say there are already provisions that CMS has made for individuals under special circumstances to be able to visit their loved ones. That would allow those close family members to be able to visit in times of emotional distress or end of life. There are a myriad of circumstances where they have that ability.
Okay.
This just codifies it within our state regulations to allow additional individuals that would be considered that could provide those services to the individuals in the facility.
Thank you. I may have a further question, Mr. Chairman, but Senator Alvarado has a question that may answer mine.
Senator Alvarado.
Yeah, I think what we did in the law was that we established an essential personal care individual. So where there might be people that, couldn't see people from the outside. We heard all those stories as legislators. This allows one individual to be designated as an essential visitor. And then that person would have to probably go through a lot of the same testing and things that are required from the employees and do those sorts of things, but that one person that could be designated to come in and address that person's issues to kind of be that link to the outside world, I think. And I see that Section 2 addresses a lot of that in the regulation in terms of designating one individual to do that. So I think this is very important. We heard so many stories. I think everybody did. I witnessed a lot of those stories, but this allows that and basically just complies with what we passed in statute. So I commend you for it, but I think it does the job.
Thank you, Senator Alvarado. Senator West, to follow up.
No further questions. Thank you.
Thank you. And again, as Senator Alvarado stated, we do appreciate the willingness to make this happen. I know that was very difficult for so many people in that difficult time, and we're glad that we've got that now established, that we can have someone there to communicate. And so again, thank you. I want to thank you personally myself.
Thank you all.
Thank you for being with us today. Please call the next regulation at this time.
Department for Aging and Independent Living, 910 KAR 4010 with a staff suggested amendment.
This regulation establishes the process for submitting curricula for cabinet approval that will meet the minimum training requirements for direct care staff serving individuals exhibiting symptoms of Alzheimer's or other dementias. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself today for the record?
Sure. My name is Victoria Elridge. I'm the Commissioner for the Department for Aging and Independent Living.
I'm sorry, we're not able to hear you. Could you please repeat that again?
My name is Victoria Elridge. I'm the Commissioner for the Department for Aging and Independent Living.
Thank you. Thank you. Anyone else?
Yes, my name is Jennifer Craig, and I am the Office of Dementia Services Coordinator.
And I am Phyllis Sosa. I'm the staff assistant with the department.
Thank you, ladies. We appreciate your time today being with us. There is a staff amendment. Is there a motion for approval of the staff amendment?
Motion.
There is a motion, and there is also a second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee for the ladies? Senator Alvarado, go right ahead, sir.
Thank you very much, Mr. Chairman. My understanding, this is regulations in response to Senate Bill 61 that was passed from last year, and I see the heads going up and down, so I'm assuming it's from that. I know when we had that bill before my committee, it had to do with predominantly home health services and people that were home health going into people's homes to address concerns, to make sure they had adequate training for that. When I read the subcommittee substitute, it seems to go beyond that in the regulation. And I'm hoping you could address some of that, because my concern is always with regulations that it's not in response to what we're passing, but we're creating language outside of what that bill originally was meant to do. That's my concern. Training is great. People need to be trained on knowing how to recognize aspects of dementia, and I deal with this in my life every day in what I do for a living. My worry is that we're having regulations that are going beyond the scope of what that original bill was meant to do. So maybe you could address, because the way I'm reading this goes beyond just home health service agencies. It'll go to personal care provider agencies, which seems to branch off into assisted living facilities, personal care homes, et cetera. Could you address some of that?
Absolutely, Senator. Specifically within 216.713, as cited 1 through 3, it states that this regulation would work with individuals who receive services that are in facilities in which they provide services to individuals who exhibit Alzheimer's disease or other dementias, and therefore assisted living communities would encapsulate this entity to meet the statutory and regulatory requirements.
So this apply? Can you give me all the agencies this would apply to then?
Based upon the way the regulation is written at this time, it would include home health agencies, personal service agencies, and assisted living communities that employ directly or by contract aides or other non-licensed personnel that work extensively with individuals who exhibit Alzheimer's or other dementias.
So assisted living facilities that have a dementia unit of some sort or take care of people with dementia, it's going to require all of them to have that training, correct?
Correct. Yes, and that again is per the statute as it states facilities that work with individuals with dementia.
Personal care homes, would those be affected by this?
Yes, as if they work with a home health agency or a personal service agency.
So if it's a personal care home that lets home health come in and treat their patients, the staff of the personal care home have to have this as well.
Correct. If they employ a home health agency, yes.
All right, that's a bit broader. Like I said, I'm not about people need training, and that's fine. I know when Senate Bill 61 was passed, that was Senator Meredith's bill, I believe. It was regarding home health services, and that's, I think, how it was even put on our agenda, and that's what was discussed, was the need. This probably goes a bit beyond that. That's my only concern, and I always worry about that when we as a body draft laws, we want to make sure it's within the bounds of what we passed there. That's my only question. Thank you so much, Mr. Chairman.
Thank you, Senator. Are there any other comments or questions? Senator West.
So I have a question for Senator Alvarado. So there's a simple way to cure that. So we can ask for a deferral. Would you propose that we ask for a deferral, that this reg be a little more narrowly tailored to the bill?
No, Mr. Chairman, thank you for that. I'm reading. I got the bill in front of me. So I'm looking at definitions of the bill, and under the definitions, facilities or programs means residential facilities or home and community-based service programs, and include but are not limited to personal service agencies and home health agencies that have residents or program participants who exhibit symptoms of Alzheimer's disease or other dementia. I know this language is what came out of our dementia task force a couple of years ago. This was a bill that was a product of that. I'm not going to make any recommendations that it be tabled or deferred. I just want to point that out. My only concern is that that bill was supposed to be for home health agencies. This is something I don't disagree with. People need training in this field to recognize these things. It has a larger ramification than that. But the way the bill is drafted, it's pretty specific, and I think it does include that. I just wanted to make it clear for the record that we're including ALFs. We may address some of that in a committee hearing later on this week anyway. So I just wanted to put that on the record. But thank you.
Thank you.
Thank you, gentlemen, and thank you all for being with us today. Appreciate your time very much. This concludes our agenda of the January meeting. The compiler will now announce to us the time for the next administrative subcommittee meeting.
We're looking at February 7th at 1 p.m. That would be a Monday.
February 7th at 1 p.m. is the date for our next meeting. We appreciate everyone being here with us today. There being no further business, we are now adjourned.